Hello, I'm Martin Rogers. I'm a partner of Clifford Chance. I'm the head of our litigation practice in Hong Kong and Asia. I'm also the general editor of the Hong Kong White Book, published by Maxwell. I'm going to talk about civil justice reform in Hong Kong under the new rules, effective 2nd April, and in particular about evidence and trials. Under the new procedure, a key development and change will be much more effective trial procedure. How's that going to be achieved? It's going to be achieved in a number of ways. First, pleadings verified by statements of truth are going to make the issues to be dealt with at trial much more focused, much clearer for the judge who's trying the case. Secondly, discovery is going to be much more limited and focused. Gone the wide test of discovery that we used to have, now a much more focused test. Thirdly, getting rid of cases at an earlier stage before trial, whether it's by sanctioned offers or mediation. The intention is certainly that less cases will actually get to trial. But what about the cases that do get to trial? What's going to happen to them? An absolutely fundamental principle underlying the new rules is the case management conference, active case management, and milestone dates. Milestone dates includes the trial or the trial period, and that is not supposed to shift, save in exceptional circumstances. An application can be made under Order 25 Rule 1B for a party to vary a milestone date, but the rules are very clear. Under subparagraph 3, the court shall not grant an application under paragraph 2 unless there are exceptional circumstances justifying the variation. So what that's intended to mean is that in very few cases, only exceptional circumstances, is a trial going to be adjourned and delayed. But, and this is the fundamental issue I wanted to get everybody thinking about, there is a really big tension between that principle and that set of rules and the rules built into the very first order in the new White Book, Order 1A, concerned with the underlying objectives. Look at Order 1A, Rule 2. Look at it very carefully. It's very clear again. Under subparagraph 2, in giving effect to the underlying objectives of the rules, the court shall always recognize that the primary aim in exercising the powers of the court is to secure the just resolution of disputes in accordance with the substantive rights of the parties. What does that mean? Well, it actually, on the face of it, contradicts the case management rule restricting movement of trial dates, save in exceptional circumstances. It means that primarily, and the wording is very clear, the courts have to see that justice is done at trial and that the substantive rights of the parties are determined. So let me finish by dealing with one particular issue. What about the party who thinks he's being well represented, but in fact, quite frankly, has a lousy set of lawyers representing him who haven't prepared the case properly for trial? And my understanding, informally, of the judiciary's view is that in those circumstances they wouldn't count as exceptional circumstances justifying the adjournment of the trial. But in that sort of circumstance, how is that party's substantive rights going to be recognized at a trial if they're not ready? And worse still, let's take the case where we've got two poorly advised sets of clients, both sides are not ready for trial. Is that exceptional circumstances justifying an adjournment of the trial? Or is the court going to press on and insist on a trial where that initial provision in Order 1A, Rule 2, subparagraph 2, may not be met? A different result may be achieved than the true determination of the parties' rights. It's a challenge that Hong Kong has taken on by adopting underlying objectives. In the UK, with overriding objectives, quite clear, the court's going to give primacy to the court's resources and a preset timetable. Parties are going to be left to sue their lawyers if that's a remedy available to them. So that's the issue. We'll have to wait to see how the judiciary deal with it when they start dealing with questions of trial adjournment under the new procedures. Thank you.